Hi, how are you all? Yeah, I couldn't be happier to be here. This is just such a fascinating conversation, and there's so many different perspectives to it. I want to thank Bill for this perfect arrangements. Martin and the provost had some things interesting to say this morning that I want to bring up. And I have a very interesting role, and it's my lot in life, is I have a law degree, which comes with some baggage in many different ways. But I use it in very interesting ways that are really about mitigating risk in some sense. So we're going to talk a little bit about that question. But I have a limited amount of time really to have this conversation. So I'm going to focus on some key questions related to the fears that people have with respect to copyright and the kinds of misunderstandings related to copyright and really the social purposes of copyright. So I'm going to try to roll those all into like a concise 20-minute package, and we'll see how that goes. I've been talking about copyright. I have this luxury of thinking almost exclusively about copyright and education and copyright and technology and copyright and information. And it occurred to me, this seemed like a good idea at 2 a.m. in the morning, which is usually when I end up doing my PowerPoints. But it occurred to me that I've read thousands of cases, and I've looked at many different opinions from the courts, and I've looked at lots of statutes, and I've looked at lots of law review articles, and I came to this conclusion at some point about a year ago or so that most of everything I needed to know really was in South Park and Gilligan's Island about copyright. And so, and let me tell you why. South Park, you all know South Park, right? South Park, Colorado, it's these little, diminutive little fellas that go around and just never curse or do anything bad. And there was an episode recently that was about the internet. And what happened in that episode was that the internet dried up. The internet disappeared, and there was just like chaos in the town of South Park, right? Because they needed internet, because they couldn't function without the internet. So they started making this conversation, well, there may be internet available in California, and it turns into the grapes of wrath, right? So they're all traveling to California to get some internet because they hear some's there, And I sort of gathered from that digital technology is not going to go away, and it's changed our model for lots of different things, and it's made things possible that we never envisioned before. So when Stephen was talking this morning, it really gave me a sense of that direction, and Provost Tanner. The Gilligan's Island question is even more interesting to me. You all are familiar, right? The 3-hour cruise, no luxuries, no motor cars, uncharted desert isle, that part. And they crash, and you feel bad, right? So episode 1, 2, 3, there's sort of this struggle of what they're going to do on the island. And as we move forward, there's the first time that Gilligan and the rest are going to escape from the island is very exciting, right? You're like, yes, the series is going to end because it's awful, right? But it doesn't end. They don't move along, right? So here's my theory, and bear with me on this. We have the professor. The professor is like the brightest person in the entire world, right? So they have no luxuries, and they have coconuts and some thatch things, and he's able to create like a judicial system, He can create electronic devices. He can create all these things he needs to have out of this island stuff. And so, I admire him because I think he's a bright guy. And they come to each episode or every third episode, and they get ready to, sail away, right? So they create a raft. And the first time, Gilligan screws it up, okay? The professor's in the boat, right? So the second time, the professor gets in the boat, right? Gilligan screws it up again. And I start wondering, well, why does the professor keep getting in the boat? Because he ought to know, being the bright guy that he is, that they're not going to get off the island and reach the shipping lanes. And it's really about risk and benefits. It's possible things will go awry, but there's going to be a great benefit in taking that risk. And so my framing of copyright really is on that question. I disagree with Stephen to some degree that there's zero risk because I have the baggage of being a lawyer. Climbing up this flight of things over here brings risk to me. When I was in tort law in law school, I stopped driving for the first semester. It's like, this will ruin your life because you'll have an auto accident. So there's some risk, but I think this open access is really one of the ways that we need to think about we can do the kinds of things that we want to have to accomplish, and can do it within the framework of copyright law. So I'm going to talk a little bit about that. This is me, by the way. I'm the endowed chair for scholarly communication, and I feel like I need to stand like that when I say that. And you also can ask me questions later, right? When I'm done today, Buttler, you can just Google me and you'll find me to ask me stuff about copyright because I'm going to confuse you. So this question, you have the right to. What's the end of that sentence? Remain silent, right? That's what everybody says, you know? And so I'm on this, I'm maybe ill-conceived quest to be this, manage your copyright. You know, you have the right to manage your copyright, and part of my conversations are really about this is within your purview as the faculty author to change the world by managing your copyright in that sense. So we're going to talk a little bit about that. Nutshell view of copyright for those of you who have not been exposed to it is that it is very broad and as a general proposition protects any original work that has some creativity that's fixed. So we have this system for protecting copyright. It's very long. I think David mentioned this morning, I found this relatively interesting and related to copyright. The term of duration of copyright now is life of the author plus 70 years, you know, and he used the term long run. And, you know, our contemporaneous works are going to be around way beyond us. We'll all be dead when the copyright expires. So in the long run, we have to use our rights, or author rights as it's come to be communicated, in order to control our destinies to some degree. This came up this morning. This is, I'm not going to talk about the Oscar Wilde part so much, but this really came up in the context of why do we have copyright at all? Why do we have it at all? And there's really a constitutional foundation for copyright. There's this tension between copyright and the First Amendment, and we'll talk a little bit about that, but there's this foundational question that says that copyright promotes the progress of science and the useful arts by securing for limited times to authors, right? Limited times means there has to be some duration. In the United States, it's turned out that that duration could be close to forever. And writings and discoveries. So we have this social policy embedded in the constitutional framework. You know, the iteration, I was at a conference at Berkeley a few weeks ago on the Statute of Anne, which was a much earlier iteration of copyright, which was prefaced on the idea of the encouragement of learning. In the United States, we sort of migrated away from that and to promote the progress of science and the useful arts. And a lot of the conversations are, how do we do that? What does promote mean? So, you know, I agree that copyright reform's not necessary in order to affect open access and manage our copyright successfully. But I do think that copyright reform is going to have to come at some point to deal with all the other ancillary issues related to the internet. YouTube's not going away. And so, original work of authorship, fixed and tangible medium. So, how many copyright owners in the room? Yeah, all of you are copyright owners. You joined some club at some point when you created original work and fixed it. So you have those rights under copyright law. And the question is, how are you going to use those? You know, facts are not protected, ideas are not protected under copyright law. And we had this conversation in addition to text messaging last night. It's like, really, what is protected by copyright? And this is where you start to see this First Amendment question. You know, we don't protect ideas and facts because there should be some accessibility to certain kinds of things. You know, so does scholarship start fitting into that model? There should be accessibility to it for these fundamental reasons. I'm not worried about expired works, statutory defects. U.S. government works as a very interesting dilemma. And it's actually an exception in the law to the exclusive rights of copyright owners. And for all practical purposes, it says that there's an inherent social value in having access to these works produced by the government. And they should be accessible to all because it goes back to the point that the provost made this morning about democracy. You know, we need access to them because it's a democratic principle to understand and have information in that way. And that U.S. government works concept in the statutory law comes from an 1834 Supreme Court case involving, it's called Wheaton versus Peters, for those of you taking notes or tweeting, I guess. I didn't say it in 140 characters, though. But, and for all practical purposes, that was a complex case. It was decided by John Marshall, who sort of cut out the role of the judiciary in the Constitution. And The question was some publication issues, some common law copyright, some kinds of things, but really what one of the conclusions was that this guy who reported the Supreme Court opinions, wrote them, annotated them, literally reported them, couldn't have copyright protection in them because there needed to be access to those understandings of the law. And that's a public policy question that really led to this U.S. government works exemption. It's not that government works aren't original or creative or fixed. It's that we've decided as a policy point to not make them protectable by copyright because the accessibility is the core question. And that sort of starts to relate to that First Amendment question as well. I guess I should talk about these in the beginning. You know, these are exclusive rights of copyright. If you're a copyright owner, theoretically you can prevent anyone else in the world from reproducing that work, distributing that work, preparing derivative works, which is a difficult, interesting conundrum in the scholarly world, public performance, public display. And because of some bonus items added in 1998 in the Digital Millennium Copyright Act, now we have sort of file level protection for some sort of preventing anti-circumvention of things that is a whole other 3-hour conversation. Okay. My two great inspirations were Elvis and Richard Nixon. So I visit the Nixon Library in California. The town escapes me right now, but you all know that. And it was weird because when I went there, the Watergate exhibit was gone. And I just found that kind of creepy. You know, you walk in the Watergate room and everything's missing, and I thought, what's up with that? But as it turns out, they really were working on it, and they're going to expand it. But, you know, it was kind of odd. So we have this question, you know, how do we know assess ownership? Because in order to understand how I do the licensing or the contract, publication agreements, I have to know who owns it. So we have possibilities are the person that created the work, that did the originality and fixed it. We have the person that is an employee, work made for hire doctrine, which is greatly misunderstood. We have the possibility that that copyright was assigned to someone else, and that really is the publication agreement history. The history has been that we assign them to the publisher. And then we have inherited, of course, because inherited would be a part of life of the author plus 70 years. You know, at some point it has to pass along the way, which is a great conundrum for some of my digital library colleagues in understanding the status of any given work at any particular time. So, creator of the copyrighted work, that person creating the originality, that's an ideal candidate. The creator is the author in copyright terms, and what happens really in the academic world is this dilemma. Work made for hire. You have a creator, you have an employee acting within the scope of their employment for an employer. In the work made for hire situation, the employer is the copyright author, even though they didn't literally create it. If the creator is the copyright owner, they own the copyright. Because of the complexities of the work made for hire doctrine in the United States and the understanding of the traditional role of faculty members with respect to their institutions, many institutions have created intellectual property policies that the university doesn't assert ownership in works of scholarship. And I believe UNT says something like that when I looked at it about a week ago. And which means that you as the faculty author of copyrighted works, and I'm not going down the patent law question or the invention question, but with respect to the copyright, you're the owners. You're the owners. So not only do you have the right to manage that copyright, you probably have an obligation to manage that if you want to protect your interest. And so in that sense, that's kind of the question of starting about the ownership. You have under the law the ability to use the law to protect your interest or use the law to make it available. So it's very consistent with copyright law in that way. I'm not going to talk about that question. I could go back to that, but it's another conversation. You all undoubtedly have at least had publication agreements. How many have actually read them? Yeah, so all the lawyers raised their hands. I'm just kidding. Yeah, they actually say something that has some potential legal effect, some legal force. And you know, and I often get the conversation, I think Tyler maybe mentioned in his presentation about coming along and wanting to do X with it. You know, one of the obvious questions is, what's your publication agreement say? And often the response is, what publication agreement? You know, it's like, well, I know you had one, I just don't know where it's at. You know, I can predict, based on history, that you probably assigned your copyright to the publisher. But I don't know that, but I can predict that. And the magic words, you know, the law is very interested in sets of words that have gravitas, and they've existed for very long. And, you know, if you're reading something that says, I hereby, that's always red flag. You know, I hereby, you know, da-da-da. Transfer, assign, grant, give. You know, we're also very redundant in the way that we talk. I represent and warrant, or I warrant. So when we start looking at some of the deposit agreements that some institutions have for their institutional repositories, they have some of this language in there. You know, that language of what you're going to do, what your obligation is between the faculty member and the institution. Sometimes you get this odd language, I hereby indemnify. You know, I do in-licensing for content from folks like Elsevier and elsewhere at the university libraries. And sometimes we get this language, I indemnify. You know, I'll stand behind my decision making and pay you money if I'm wrong. You don't tend to get that too much in some situations. But the key point, at least for my purposes, is, you know, read the publication agreement. That's useful. But also really think about how you're going to manage those rights. Do you want to do an assignment, or do you want to do a license? And one of the things that open access, as I understand it, is framing it as a non-exclusive licensing question. So you have the deposit of a physical artifact, but you also have that question of what interest in that does the institution have? And oftentimes there will be some kind of language about a non-exclusive license, you know, sometimes fully paid up worldwide on all technologies, now known or later developed, or some kind of such language. There's some similarities. And you really need to understand that as a faculty member, and to the extent that you create a program related to open access, it's useful to have somebody at your institution to interpret that or translate that or help with those kinds of issues. You know, how do we deal with our faculty members with respect to their understanding of publication agreements, but not only open access, but downstream of that. You know, how do we comply with NIH, or, you know, if FERPA passes, how do we comply with that? How do we make those understandings? And I think that's going to be part of the conversation. Publication agreements ultimately become contracts both parties sign, and then at that point they become enforceable in some sense. So, things to look for. You all pretty much have a good sense of this aspect of your scholarship. Do you want to do an assignment, or do you want to do a license? You know, if people ask me, I go, do a license. Don't ever assign your copyright. And then that bumps directly into that question about what happens if they won't publish it if I don't assign it. And I think that you need to let the person who's in the shoes make that decision, and you need to structure it in a way that gives them the latitude to make that decision. You can't force that decision. But you can structure that sort of pre-existing non-exclusive license to the repository, and then some subsequent exchange later that the publisher takes with notice that that license exists out there, the non-exclusive license. And that's a perfectly amenable way to use the law of licensing or contract to move forward in making those available. And I don't, the whole question of addenda, which Spark has an addendum to license agreements. There's some other ones out there. They have great similarities. And that came up today, I think, in one conversation, sort of attaching an addendum. I think Michael Tanner might have talked about that, because a lot of institutions have them. And essentially what that addenda is saying is that no matter what this publication agreement says, this paper is going to get literally attached to it, and it's going to define some of the terms. And some of those terms are going to be based on what do we want to do with that item in the future, you know, and just rudimentary things like, you know, another benefit of open access that I think we haven't talked about today is the great dilemma in how do we deliver things to students for teaching purposes. You know, how do we deal with those permission barriers with respect to quote-unquote course packs, electronic reserves, or using electronic content, and to what extent do we have to then license those versus having them just available in that construct? Because that's a real dilemma for teaching purposes. And, you know, so my general position is that you should strive to avoid transferring your copyright, because that's what you own. And you probably should negotiate the agreement. You know, one of the great fears that I encounter all the time, and you know, this is only anecdotal, but one of you may ask this today, so I may preempt that. You know, the hand will go up and they'll go, well, you know, if I ask them to make a change in the agreement, won't they just go, well, we don't want to mess with you because you're a troublemaker. You know, we have other people that want to publish with us. And you know, I haven't talked to a single person in 15 years that the publisher's gone, well, you asked for changes, we're just not interested in you anymore. You know, so I think just asking alone can start to change the conversation. I think that it's been not uncommon to have people amenable to making those exchanges if you ask. You know, one of the principles of contract law, or applies to publishing and everything else, is that if you create the contract favors you. So I'm trained in law school to create contracts that favor the interests of the person I'm working for, and it's really up to you to ask to make changes. And if you don't ask to make those changes, then those changes don't happen. So even making that, what I think is a difficult step, for some people, really can make a fundamental change in how we manage our copyright, or how we control our authors' rights in that nomenclature. And the other thing that I also think is important is that it really is critical to understand how long copyright lasts, and how that you can create clear change through time. Because as we look at something 80 years from now or 60 years from now that we still know is theoretically under copyright because everything, at least in the United States, is swept into the copyright, we'd like to know in the library community what we can do with that. And one of the ways that we can know that is something like the Creative Commons efforts. You know, we're starting to attach licenses to artifacts in that way. But the other way that we could know that is to have us as a community managing our copyright of our research. And you know, and it's a more complex question, because Martin and I talked about this yesterday about video and those kinds of things. It's not that they're not doable. They get more complicated. They get more complicated. I think Tyler brought this up about introducing third-party works into things. That complicates the conversation. But for the scholarly journal article that you create, I'm pretty comfortable with moving it in the open access, and I think that lessening risk is fairly straightforward, because I think it's really modest at best, to the degree that if I walk up those steps, there's risk associated with that as well. Okay, I'm done. I'm done.